Some of the court's more savvy public defenders have suggested that maybe part of what's happening in these cases is appeasement, where Chief Justice Roberts is sort of holding his fire and saving the court's capital for more head-on confrontations on the merits of these cases. The problem I have with that, Jim, exactly. The problem I have with that is whether or not this is, Munich in 1938. One of the things that appeasement does, right, is it enables the aggressor to be more aggressive. And in the interim, you have the continuing costs, you have the continuing harms that are wrought by all of that. And so it just seems to me that, like, if the Supreme Court is going to draw a red line, I would have thought it would have done so by now, but certainly in some of these merits cases that are coming up soon. Because, what we're really seeing is this remarkable difference from the first Trump administration, where during that administration, Jim, the president was subject to a whole bunch of constraints from Congress, even when there was Republican control, and from his own, internal bureaucracy. Now, both of those constraints are gone, and everything has become just sort of what can the courts do versus what can't the courts do. And at least so far, the lower federal courts have been a huge part of the story. I mean, as of the end of November, there had been more than 150 cases in which lower federal courts had issued, some kind of injunction or coercive relief against a Trump administration policy. That's a really striking number, even accounting for the 22 or 23 of those in which the Supreme Court granted stays. The majority is still blocking. But that, Jim, is not a long-term solution. That's not a long-term way of preserving the separation of powers. If anything, it's a holding action. And I think the question is going to be what gives?